Well, good morning, everyone. My name is Jim Reedy, and this is Sheehan Finney's webcast of the December meeting of the New Hampshire Tech Alliance HR Exchange. And this is our normal breakfast meeting, but as you know, during COVID, nothing is truly normal. We've gone virtual for this program year. So this is our December meeting, and it's going to be a great one. But before we talk about that, I want to just briefly talk about what's coming next month in January and then the following month in February. On January 6th, we've got Brianna Brudich, and Brianna is a healthcare professional, and she's going to be talking about affordable ways employees can change their lifestyle habits into healthy ones. So as we all look into the new year and New Year's resolutions, Brianna is going to be talking about that and some things you can do at home and in the office for a healthier lifestyle. It's a bit of a departure for us from other legal topics, but we think it was truly important to insert that into our program for the new year. In February, on February 10th, we've got JP Harris, our partner JP Harris, is going to be talking about avoiding and responding to data breach issues with remote workers. So with COVID, many employers either furloughed their employees or had a lot of them go remote. Some of them are still remote. And as we go into the next season of COVID, it could be they're remote again. And with that, employees using laptops and other devices, whether or not they are making their organizations more susceptible to data breach. JP will be talking about that and some steps that you can take to insulate and protect your organization from data breach. I was just dealing with a client yesterday when they had a massive malware data breach that shut down their operations completely in October, and they're just now in December rebuilding their payroll and other processes. So it can be devastating. I had another client that inadvertently sent out their payroll to a former employee and had to go through steps, but they have operations all over the US. They had to go through various data breach laws and notification throughout the US. So big issue for sure. So this program, like our other programs, breakfast programs through the High Tech Exchange and otherwise through Sheehan Finney, is an HRI certified event. So you get HR credits for being a part of this. That will be a part of the program. You'll see information at the end of the program on that, as well as the programs I just mentioned. So without further ado, I'd like to introduce our presenter, my partner, Karen Whitley, member of the employment group at Sheehan Finney, splits her time between our Boston office and our New Hampshire office. And she's going to be talking about a very interesting intersection, navigating the four-way intersection of the FMLA, the Family Medical Leave Act, the FFCRA, the Families First Corona Response Act, Workers' Comp, and the ADA. As you know, and some think that there's a safe harbor because the FFCRA is ending supposedly on December 31st. But of course, the FMLA is going nowhere. Workers' compensation and the ADA will remain. And it could be that the FFCRA is extended if the coronavirus surge continues. But lots of interesting issues, employees saying that he or she cannot come into work because of personal illness or caring for someone else or something that might arise at work and so on. And it truly is an awkward intersection. These four laws are not aligned. They were not designed to be aligned with each other, and there's a great deal of confusion. So here to sort all of that out is my partner, Karen Whitley. Please welcome Karen.
Good morning, everybody. Next slide. So, what is one of the things that we've learned in 2020? Go ahead. Basically, our pot of alphabet soup has gotten even bigger, and I want to pause here and give a big shout out to our marketing team, the brains behind the operations, Kelly, Liz, and Andrea. And this graphic goes out to Andrea, so thanks to her for putting this together. But as you'll see, we've learned a lot of new acronyms in 2020. Some of these we may be familiar with from past years, but there's a whole new vocabulary that we've learned. Next. And sticking with my metaphor about the alphabet soup, this may look pretty digestible or manageable. Go ahead. Until the moment you take a call from your employee. You know, it could go something like this. I think I have a fever. I just had a really bad coughing spell, difficulty breathing. When I went to sit down to catch my breath, I fell and hurt my wrist. Oh, and I meant to tell you, I just got an email that my son's school is going fully remote. So we are now living in a time where the new laws, the old laws, and some unprecedented workplace dangers are all overlapping. And it is undoubtedly confusing and overwhelming to know how to react, how to respond, what to do when an employee comes to you with an injury or an illness and a request for a time off or ask for another accommodation. So taking smaller sips of this hot soup is best. Next. And the way that we're going to do that today is to just break down the 4 key laws. So as Jim mentioned at the beginning, we'll be talking about the FMLA, the ADA as amended, the ADAAA, the New Hampshire Workers' Comp Law, and the FFCRA. Next. Just want to remind everybody, in presentations like this, you'll hear a lot of sort of one-liners that might stick with you. Oh, I heard that this is the way it's supposed to be done. I just want to remind everybody that this is just general advice or general information, and it's not a substitute for legal advice. You really should make sure that you are looking at your specific situation with legal counsel to address your particular needs. So there are some important steps that you can take even before you receive a phone call from an employee who needs leave. And we'll talk about some of those steps this morning and basically do some triage. What can you do up front? What do you need to do at the time that you learn about a specific request for a leave or an accommodation? Then we'll go through some scenarios where these laws might overlap and some areas where they might not overlap because, as Jim mentioned, they're not aligned. And I'll just end with some discussion of the how COVID-19 might impact us all going forward. Next. So just some quick reminders. Remember that the FMLA, the ADA, and FFCRA do not apply to all workplaces. The FMLA, ADA, FFCRA, and workers' comp will not all apply to every situation, but there could be situations where more than one law applies at a time, and there could be situations where the laws follow one another. You exhaust one law and or the leave available under one law and move on to the next. So the first step is going to be to figure out what law applies to your company. So before you get that phone call, figure out what laws apply to you and to your organization. And the key question really is going to be, how many employees do you have and how long have you had that many employees? Next. So the first, FMLA. Does it apply to you? It applies to all private employers with 50 or more employees, and also to public agencies and government employers, schools, regardless of their size. And then when you're looking at what not, to decide how many employees you have another set of questions to ask. How long have you had those employees? The 50 employees is counted by looking not just at your full-time staff, but also your part-time, your seasonal, your temporary employees to see whether there are 20 weeks in the prior year or in the current year, and the weeks don't need to be consecutive, where you have had 50 or more employees. You'll also need to look and see whether you have any joint employers. Do you have a parent corporation that is really a joint employer with you? And so you will need to make sure that you count if there's a joint employment relationship, that you're counting the employees in both organizations. Next. The ADA. It also looks back at the 20 work to see whether there are 20 work weeks with a certain employee threshold, but the ADA is much lower threshold. It's 15 employees plus all local, state, and government agencies. Next. Workers' comp, very simple. You just need one employee for that to matter. FFCRA, as Jim mentioned, this is set to expire on December 31st, 2020. This is a law that came in fast. We worked it hard. It's potentially done its job by keeping people employed, giving them some leave for the time that they need it. perhaps has resulted in fewer COVID-19 cases, and has provided some relief for families with children when their schools are closed. But it applies to employers with fewer than 500 employees. And then even though, again, it's those employees are counted, not just full-time, but you look at the full-time, the part-time, temporary employees. You also look at employees who are on leave, employees of joint employers, but you don't need to count employees who are furloughed. So we have clients that started off with more than 500 employees in 2020, and as a result of layoffs and downsizing and furloughs, now have fewer. So where the FFCRA might not have applied to them at the beginning, now it does. And then even though it applies to all employers with fewer than 500 employees, there are some exceptions. So even though it applies to them, smaller employers with fewer than 50 employees might be able to take an exemption for certain employees for certain reasons. So there's a series of tests set out in the FFCRA regulations about what you need to do to take this exemption. You don't need to file anything with the Department of Labor, but you do need to do your homework and document the fact that there are some people who have asked for leave who are hard to replace. They're key. It would cost the business. It would basically incapacitate the business if those employees took a leave. And the leave that they can be exempted from is the child care leave. And we'll get into that in a minute. Healthcare employers may also be able to exempt some healthcare workers. When the FFCRA first came into effect on April 1st, the understanding was that if you were basically a healthcare organization, you could make a choice as to whether you give paid sick leave to your employees or the expanded family medical leave. But what has happened since in September, the regulations were updated to make clear that the employees that can be exempted are only two categories. Those healthcare providers who would be able to issue healthcare FMLA certifications, so doctors and licensed nurses and et cetera. But also the employees who could be exempted are those who are in the process or are capable of providing diagnostic or preventive treatment services or that are integral to patient care. So it is a narrower group of employees, but it does apply to those organizations. It's just that they can take some steps to say to certain employees, you are not eligible for this leave. Next. So the second step that you can take before you get that call from an employee about the coughing and the broken wrist is to become familiar with what each law requires. Next. So under the FMLA, familiar to many of us, it's been around for a long time, an employee can take up to 12 weeks of unpaid leave within a 12-month period to care for the employee's own serious health condition or the serious health condition of another family member. This is job protected leave where the employee can return to the same or an equivalent position. There are some exceptions. For example, if there's a key employee in the top of the company, it might be very difficult to have that person be out for 12 weeks. Also, they can return to the same or equivalent position unless there's something that has happened to their job that would have happened even if they had been there. So if this situation, the COVID pandemic, has required employees to take some drastic job actions and furlough or lay off individuals, if that would have happened to the person out of FMLA, that can still go forward because it would have happened to them regardless, as long as that's well documented. I'll just also remind you that the FMLA does give 26 weeks or up to 26 weeks of military caregiver leave to take care of an injured service member. But that leave typically would not also be covered by the ADA or workers' comp or the FFCRA. So we're not going to get into that in any detail this morning. Next. So the ADA prohibits employers from discriminating against employees or applicants if that applicant or employee is a qualified individual with a disability. So is there some limitation that they have that interferes with their essential functions, to their ability to do their essential functions? So the ADA also requires an employer to provide a reasonable accommodation to employees or applicants to help them perform the essential functions of their job. So because that is where this law most closely intersects with the FMLA and workers' comp and FFCRA, that leave, the reasonable accommodation, that's where we're going to focus this morning. And I will just point out even and further that it is pretty clear that an unpaid leave of absence can be a reasonable accommodation under the ADA, although it does not need to be an indefinite leave. So somebody can't say, I need just to be out of work until I feel better or until the pandemic is over. That's not going to be sufficient. Next. So workers' compensation, as you know, is a state-run program. It allows workers who are injured on the job to receive certain types of compensation, including medical expenses and some wage replacement while they're out of work due to a workplace injury. And employers with more than 5 employees also have the obligation to reinstate workers if those workers are able to return within 18 months of the injury. Next. So back to the FFCRA. As I mentioned earlier, there's a paid sick leave component and an expanded FMLA component. So the paid sick leave offers up to 80 hours or 10 days of leave for 6 specified reasons. So there's a notice that all employers should have posted at this point. Maybe it's almost time to take it down, but at this point, there are 6 reasons. If an individual is subject to a local, state, or federal government order requiring them to quarantine or isolate, they would be able to take these up to 80 hours of paid sick leave. And it is proportionate to the number of hours they work. So if they're full-time, they're getting the full 80 hours. The second reason, if they're advised by a healthcare provider to self-quarantine for whatever reason that may be, if they are at high risk, if they've been exposed, if there's some reason that they are advised to self-quarantine. Third, if an employee is symptomatic, it has, if the employee has some of the COVID symptoms and is seeking a medical diagnosis. The next reason is if there is a bona fide need to care for an individual who is subject to a quarantine or is symptomatic and is seeking a medical diagnosis. And the fifth reason is to care for a child who's under 18, whose school or child care provider is closed or unavailable. And the final reason is sort of the bucket that has yet to be filled, other reasons specified by the Secretary of Health and Human Services. So we don't know what that is. That has not gotten any more definition at this point. So basically there are the 5 active reasons. Compensation. The FFCRA requires that this leave be paid. For individuals who take the paid sick leave for reasons that relate to their own health. So if they're quarantined or isolated or seeking medical diagnosis because they're symptomatic, they are entitled to their full pay for those 80 hours, up to $511 a day or $5,110 over those 10 days. If they are taking the leave to care for someone else, so if they're taking care of a child whose school is closed, or if they are taking care of someone in their family, an individual who is subject to quarantine, who are symptomatic or who has COVID, they would get 2/3 pay for that period of time. But remember, the employer is eligible to take a tax credit for any money that they pay out to those individuals for those reasons. The second component of the FFCRA is the paid expanded family medical leave. This kind of piggybacks on the 5th reason under paid sick leave, which is to care for a child whose school or daycare is closed. So under the expanded paid family medical leave, if an individual needs to be out of work, cannot work or telework during a period of time because they're child is out of school due to the daycare or school being closed, then the employee can take up to 12 weeks of leave to care for that child. But remember, the first 2 weeks of this leave would be unpaid. They could use the 2 weeks of paid sick leave that we talked about before. They could use some other form of accrued leave, which would give them full pay as opposed to 2/3 pay during those first 2 weeks, or they could take it unpaid. So for this type of leave, compensation is 2/3 pay. Okay, next. So the third step in trying to figure out whether these laws apply and what you do when you have a phone call from an employee, this step really needs to wait until you get that phone call or that email to figure out what specific facts are at issue. And you'll be at this point really digging into what are the specific facts that apply. And I want to just give you some guidelines as you start to look at each specific leave request. First of all, don't assume that a particular law applies. If you are an employer that is covered by the FMLA because you have 100 employees, don't assume that everyone who comes through the door looking for a period of leave will be eligible for it. Don't make assumptions that the particular law applies. Ask the questions that you're allowed to ask, and we'll go through what some of those are. Ask for the documentation that you're allowed to get, because in most cases, there is some documentation. You don't need to rely just on what the employee is telling you. And finally, this is why we're all here today, don't assume that just one law applies, because it will be kind of a rare situation where you only need to be thinking about one law. If there's a workplace injury and there's no doubt about it, it may be just workers' comp. But there are, on the fringes, many situations do implicate more than one law, and we'll go through some of those scenarios in a bit. Okay, next. So once you get that call from the employee and you're trying to figure out whether the FMLA applies to that particular situation, here are some questions that you might be thinking about. Has this employee worked for 12 months and at least 1,250 hours prior to the start of the leave? An important thing to remember is the employee must have worked for you for 12 months, but those 12 months do not need to be consecutive. And there can be a very long gap in between the first time they worked for you and the second time they worked for you. And both periods of employment can count, and that can be up to 7 years. So you want to remember that if somebody was furloughed in 2020 and is hired back 6 months later in 2021, you're going to want to look and see their prior period of employment and their current period of employment to know whether they've worked the 12 months. And then look at their 1,250 hour requirement. Has that been met? Next, you want to look at whether the employee is employed at a work site with 50 or more employees within 75 miles. Some employers, especially larger employers, multi-state employers, might decide that anybody in their organization will get FMLA leave. It's not really fair to have somebody in Massachusetts get it because that location has 60 employees, but only 35 in New Hampshire, and if the locations are more than 75 miles apart, is it fair to only have the Massachusetts employees get FMLA? So some employers do not pay as much attention to this, this particular question, but there is an opportunity for employers to do that. And so next, has the employee submitted any certifications that you've asked for to prove that they have a serious health condition or that they're needed to care for somebody who has a serious health condition? So there are forms, FMLA forms, they've been updated fairly recently by the Department of Labor, and those forms provide some information to the employer to know that this person has a serious health condition, has met that that definition for themselves or for the person that they're going to be taking care of. And another question is to ask whether the family member to be cared for is covered under the FMLA. Remember that the FMLA does not cover certain categories of people. An employee cannot take FMLA to care for a sibling or a grandparent or even an in-law. On the other hand, they can take FMLA to care for a same-sex spouse. This can get murky because there are more and more states that are putting in place paid leave laws, which have broader definitions of family member. For example, in Massachusetts, the Paid Family Medical Leave Act is going to take effect on January 1st, and there is a broader category of people who can be covered under that law. So employers are going to have to do some decision-making about who they're going to cover if they want to expand under the FMLA. But remember, FMLA does not necessarily allow someone to take 12 weeks of leave to care for a sister who's going through some sort of cancer treatment, for example. Next. The ADA. So another question to ask, or other questions to ask about the ADA to know whether it applies in a particular situation, is really to focus on, do you know whether the employee has disability-related limitations that are interfering with their ability to perform the essential functions of their job? So has the employee given you information that you've asked for? Have you gotten a doctor's note to explain what the limitations are and how they impact that person's ability to do their job? Have you asked the employee and or their healthcare provider to suggest some reasonable accommodations? You may be thinking you need to change a significant amount of, how they do their job, make bigger adjustments than the employee might need. So ask the employee to suggest reasonable accommodations, and then look and see whether they are reasonable and whether they would cause an undue hardship to the employer. And importantly, has the employee participated in the interactive dialogue to establish a reasonable accommodation? Has the employee given you some suggestions? Have they listened? Has the employee listened to your objections? If they're looking to work completely at home in a job that really needs to be done on site, are they willing to participate in that back and forth where you can explain, we've taken all the COVID precautions, there's been no incidents of COVID in our workplace. Here you can change your work hours to have very low interaction with others. So has the employee participated is a very important factor in whether the ADA would apply in a particular situation. Next. Workers' comp. The carrier will be deciding a lot of this and deciding whether workers' comp applies. But from a high level, the question basically will be, was the employee exposed to harm? And right now we're dealing with the harm of coronavirus while involved in an activity for the benefit of the employer. So an employee who contracts COVID could collect benefits under the idea that they had some sort of injury or occupational disease that they were exposed to in the workplace if it happened in the course of their employment. Next. And the governor of New Hampshire took some of the guesswork out of this equation by establishing a presumption in favor of benefits for certain people. So in an executive order that was issued in April, came out in April and was then amended in June, the bottom line is that any first responder or emergency response public safety workers, and I've given you the list from the executive order, any of those people who test positive for COVID, and a case that has been reported to DHHS, there will be a prima facie presumption that the exposure and the infection were occupationally related, which then allows them to collect those workers' compensation benefits. And I will say Massachusetts has legislation pending for those of you with operations in that state to protect EMTs and other essential workers, but there has been opposition to that because of the cost of just assuming because somebody has a certain job and worked in a certain location and tested positive that it was work related. Next. So finally, to know whether the FFCRA applies, here are some questions that you might be asking. Is the employee's absence covered by one of the 6 COVID-related reasons? And is the worker potentially exempted? As we mentioned, there's a few narrow exemptions based on the nature of the job, the size of the employer, and the reason for the leave. And then next, has the employee provided the minimal information needed to support the leave? So it will be important for employers to be aware of what documentation they can collect and keep track of that, because remember, you are eligible to take a tax credit, and you're going to want to be able to show that you made this analysis, that you determined the employee was asking for leave for one of the protected reasons, and that you got this minimal information, which includes things like the name of the healthcare provider that recommended that they quarantine, or that from whom they're seeking a medical diagnosis. And another question is, does the worker have any time left to take? So the expanded paid family medical leave component of FFCRA, EFML, that component is a form of FMLA leave. So whether the employee has any of that time left to take depends on whether they took FMLA during this period, so during the 12-month period. So you're going to want to know how much FMLA time they've taken, or whether they've told you, I'm expecting a child and I plan to take my 12 weeks at that time. They would not then have this component of FFCRA available to them. Next. So we can figure out what law applies to the organization, what the law requires, and then get a really good beginning of an understanding about whether a law applies to a particular situation. But what if there's some potential overlaps and conflicts and pitfalls among each of the laws? So we can decide on its own, does this law apply? Does this law apply? But how do you meld all that together? When should your antenna go up that more than one law might apply? And what happens if there's a different answer under different laws, which could happen? Okay, next. So I'm going to take you through some of the areas where employers trip up the most often. And these issues have real consequences for employees. Will their job be protected? Will they have health insurance? Will they be paid? Can they come back? And all of those are financial, and many of those are financial decisions, which gives employees a real incentive to complain about it if this is not handled correctly. And there are some pretty strong protections under each of these laws in terms of interference claims or retaliation claims, that you're going to want to make sure that you take the right steps, because they can be costly. So one of the areas where employers trip up most often is to just assume that because it meets a situation might fall under one law, that it automatically falls under another law. So for example, serious health conditions under the FMLA, the question is whether that's always a disability under the ADA, so that both laws would automatically apply. And the answer is no. Not all serious health conditions under the FMLA will be disabilities under the ADA. So one example is that current substance abuse may be a serious health condition under the FMLA, but it's not a disability under the ADA. And just to make sure that everybody's up to date, something that may have gone under the radar, I want to just point out to you that the EEOC is staying active and giving updates, not only on COVID-related things, but the EEOC has recently issued a guidance on opioid use as a disability under the ADA. So that was in September 2020. So be on the lookout for that. Continuation of benefits is another area where employers and employees may have different understandings. Under the FMLA, it is required that employer continue healthcare benefits. They may require the employees to contribute to those benefits, but they do have to continue to offer that group health care. If employees don't take that health care during the period of their FMLA leave, they are entitled to immediate reinstatement after the leave without any having to go through any steps. So that's an important job protection element under the FMLA. Under workers' comp, however, employers are not required to continue the employee's health benefits unless they're running that time concurrently with FMLA. Next. So under the ADA, there is no continuation of benefits requirement. But if you look through the EEOC guidances on this, the EEOC has been pretty clear that health benefits should be offered and should continue for people taking an ADA leave if healthcare is continued for other workers on other types of unpaid leaves. So it's basically a matter of consistency. If you are treating some workers favorably by giving them continuing their health care, even if you require them to continue to contribute, you have to do the same for the ADA. There could be some conflicts. Some employers' health plans don't want non-active employees on their healthcare plans. So there may be some discussion that needs to be had if you're going to continue ADA leave healthcare coverage. And then the question becomes, how long do you continue that? Because it may be that a month or two of offering that leave is appropriate, but at some point you cut that off. And that's really a case-by-case scenario that you want to work through with counsel. The continuation of benefits, back one, the FFCRA. The regulations require that benefits continue during the absence for paid sick leave as well as under the EFML. So basically, the regulations say that employers must treat employees on FFCRA the same as current employees who are not on leave. So obviously, that's a pretty important distinction. You have people who are out on leave. Maybe you have somebody who's taking the up to 12 weeks of EFML to care for a child whose school is closed, and you would have to continue to offer the group health care benefits to them, although you can require that they make those employee contributions. Okay, yep. So another issue, substitution of paid leave. Under the FMLA, the employee may ask to substitute their paid time off for their unpaid leave, because remember, FMLA is unpaid generally, but an employee can say, I'd like to use my PTO to cover as much of it as I can. The employer can also require that happen, because they don't necessarily want an employee to take 12 weeks of leave under the FMLA and then come back and take 4 weeks of paid vacation. So there is an opportunity under the FMLA for the paid leave to be substituted into the unpaid leave portion. Under workers' comp, the employer may not count a workers' comp absence against accrued paid leave, but the employer and employee can agree to use PTO to supplement the workers' comp. Because remember, workers' comp benefits do not cover 100% of an employee's wages. So there may be a gap, and the employer and employee can agree to cover that gap with some PTO. And there is also often a waiting period, so the employee may be able to use paid benefits during that waiting period before the workers' comp benefits begin. Okay. Substitution of paid leave under the ADA. There's no prohibition against the employer requiring the use of paid leave. So if an employee says, I'm not eligible for FMLA, or the employer is too small for FMLA to apply, and the employee needs, to take a period of leave for a medical reason, because they have a disability that is interfering with their ability to do their job, the employer can require the use of paid leave that employee has accrued. The EEOC has backed that up with its guidances, saying the employer also has to allow the employee to use paid leave first if they have it available. So the employer may require it and the employee may request it. There are some nuances under the FFCRA that you want to be available. An employer may not require use of company paid leave, sick time, or other accrued paid leave during the paid sick leave period. So this paid sick leave under the FFCRA is a new entitlement. It is additional to anything that employees currently have accrued. So employers cannot count this leave against both the paid sick time and use that up that employee may have already, as well as offer these up to 80 hours of paid sick time. So it's a separate bucket and has to be treated separately. So employers cannot, during those first 80 hours, require use of company paid sick leave. But they may require the use of company paid sick time or during or paid time off during the 10 weeks of EFML. If somebody is out to take care of a child whose school is closed, the employer can require that. And the employer can agree to let the employee supplement pay with accrued time. Okay. So there also may be different answers under these 4 key laws when it comes to communicating with healthcare providers. In fact, there are differences that come along with each of these 4 laws. So let's go through each of those. The FMLA does give an opportunity for employers to get some information. Now, the information you get is only as good as what the healthcare provider is going to give you, but there are medical certification forms that you can ask the employee to have filled out and returned to you about the nature of their serious health condition. How often are they getting treatment? How long is the treatment expected to last? What to make sure that you've satisfied the elements of having a serious health condition. So you have that. You also have the ability to contact a healthcare provider only to authenticate or clarify the certification. So this is important. You can't get a certification and call the healthcare provider and say, tell me more about this. You wrote this. What do you mean by this? And let's get more details about what the diagnosis is, etc. You may contact the healthcare provider to say, did you sign this, basically? And can you clarify what this word is or what this says or what this means? But be very, very cautious when asking for more details under the FMLA. However, you can ask for a second or third certification, have the employee go somewhere else to your own healthcare provider that the employer pays for, and ask for another certification or a third certification if the first and the second one conflict. So there is an opportunity to get some additional information about whether this qualifies as a serious health condition and whether it's covered by the FMLA. You can also ask for recertifications on a periodic basis, and you can ask for a fitness for duty when the employee comes back so that you know that they are now capable of doing their job. But you're going to want to be careful not to say they have to be 100% cured, 100% able to do their job, because you have to keep in mind that when they come back, it may trigger the ADA and whether they need an accommodation to do those functions. Okay, workers' comp. You are allowed to have more contact directly with the healthcare provider. Often this is the carrier that does that, but it is really much more extensive in terms of the aspects of the employee's injury, their medical history and treatment. Next. The ADA, you can ask for more information than you can under the FMLA, but it has to be job related and consistent with business necessity. So you may not know what the diagnosis is still at that point, but you are allowed to ask how the whatever the disability is impacts the employee's ability to do their job, as long as you can make a job-related connection between what you're asking. Additionally, you are allowed to ask for the fitness for duty when they come back. And as everybody is aware, during COVID, much more health information may be requested directly from the employee, including what's your temperature? Do you have under a certain temperature or over a certain temperature? You may even take their temperature. You can ask about COVID symptoms and their history of symptoms. So there is more information that is being allowed to be discussed at this point because of the pandemic and because of the the direct threat to the workplace. That's the justification for asking for those additional details. Under the FFCRA, the employer, as I mentioned, is entitled to receive very limited information. Basically, the reason for the leave and the name of the healthcare provider. But you're not allowed to ask for doctor's notes to justify a leave. At this point, healthcare providers are consumed with caring for patients, so it would quickly become unmanageable if they were supposed to be providing notes for everybody that was out on a quarantine or isolating due to COVID symptoms. So the Department of Labor has said there's not an ability to get some of those medical documents that you would normally get or like to get. So no doctor's note to justify the leave. The EEOC has said that you can require a fitness for duty when the employee comes back, especially if somebody has tested positive for COVID. That might be something that is concerning to you. However, the EEOC also recognizes that this is a tremendous burden on healthcare providers, so employers probably shouldn't push all that hard if they can't get it. So there is an acknowledgement of that, but employers at least have the EEOC support that you can ask for fitness for duty when people come back. Okay, next. Another area where we saw a lot of confusion, especially early in the pandemic, was this notion of leave as an accommodation. Under the ADA, unpaid leave may be an accommodation if it helps an employee perform the essential functions of their job. The EEOC, as I said before, has recognized that a leave need not be indefinite. So there were employers who were receiving notes from employees saying, my doctor says that I need to be out until the pandemic is over, until the state of emergency is over, because I have tremendous anxiety, or because I have a very compromised immune system and I cannot be exposed to that. But because that is indefinite, the EEOC would support the notion that an unpaid leave might not be a reasonable accommodation in that situation. And remember that an employer has the ability to choose among the effective accommodations. So an employee might say, I need to just work from home for the duration. And the employer could say, well, you are in an office within an office in a remote part of the building where you only see 2 employees that you see every single day. Everybody's wearing masks. We're all recognizing or following the COVID protocols. So you're coming into work where you drive yourself, you go in the back door and you sit at your desk and you're there. That's an effective accommodation from our perspective. So a leave might not be the necessary accommodation in that point. But the biggest thing that we saw that was a real conflict between employers and employees early in the pandemic, and I think has continued to some extent, is employers being asked to be able to take a leave or stay home or work from home as an accommodation because they couldn't afford to bring COVID back into their household because of a child or family member who was compromised or was disabled. And the EEOC is clear that employers are not required to accommodate an employee who needs leave to care for a disabled family member under the ADA. Now, if that family member has a serious health condition, then the employee might be able to take FMLA leave to take care of that person. And if the family member has some sort of FFCRA reason for a leave, then the family member, if there's a bona fide need for your employee to take care of that person, FFCRA up to 80 hours of paid sick leave might be appropriate. But under the ADA, there's not an obligation to accommodate an employee who's not disabled to take care of somebody who is. Next. Finally, intermittent leave. There may be different answers under the different laws when it comes to this. Intermittent leave and a reduced schedule may be fairly automatic under the FMLA. It's something that has been around for a while. But that same request for intermittent leave might be an undue hardship under the ADA if they're running at different times. So if you're looking just as an ADA perspective, it may be an undue hardship to have your accounts payable person out for 12 weeks or 60 days, because of the nature of their job. So that may be an undue hardship. If they're trying to when I'm saying intermittent leave, they're trying to take partial days or take off every Wednesday, Thursday, Friday, for example. Under the FFCRA, there are some nuances also under the regulations. Intermittent leave may be allowed by agreement of the employer and the employee if an employee is teleworking. So if an employee needs to stay home to take care of somebody who is sick or who is not able to go to school, intermittent leave can be allowed, and in whatever increments and whatever schedule that the employer or the employee agree to. However, intermittent leave might be prohibited if the employee is supposed to be working on site, depending on the reason for the leave. And really, this all comes down to is the employee in a situation where they might be contagious and be bringing the virus into the workplace if you allow them to come in on an intermittent basis? So if somebody is supposed to be staying home or has asked to stay home on an intermittent basis because their child is symptomatic, you don't want them to be able to come into the workplace on an intermittent basis. You want them to stay out altogether. So intermittent leave would not be allowed. But if they're only needed at home on Tuesdays and Fridays, because that's the day, those are the days their child is working, doing school remote, and they need to be home to supervise the child, that might be allowed on an intermittent basis. But there's an important clarification that came out recently under the regulations under FFCRA. If an employee needs leave to accommodate a hybrid school model, that is not considered intermittent leave. So even if you need to be home on a Tuesday and a Friday, because those are the days that your child is doing in-home schooling, even though it's just 2 days a week, that's not considered intermittent because each day is considered separately under the regulations. So a little bit of confusion for employers, I think, and employees on that. But if somebody is looking for intermittent leave, that the employer doesn't have the ability to say no to that under the FFCRA if it's to accommodate a hybrid school model. So the employer does not need to consent. Okay. So next slide. I've given you a lot of information. I thought it would be helpful to go through some examples where multiple laws might apply. And this is where it's most regrettable that we are not in person, where people can actually have conversations and contribute to this. And you wouldn't see the answers up here if I were doing this live, but let's go through some of these. So for example, when an employee is injured in the workplace and the injury is serious enough that the employee will be out of work for 3 or more days, that could likely be workers' comp because they're injured in the workplace, but it could also be FMLA because if they have a serious health condition, that might qualify. Again, we can't say it definitely will because we don't know the size of the employer. We don't know how long the employee has worked there, whether they've worked 1,250 hours. Whether they've provided the certification to justify a serious health condition. But that could be a place where those two laws intersect. Next, when the employee's FMLA leave for cancer treatment expires, but the employee needs some additional time to complete treatment, that could be FMLA leave because they have a serious health condition and they're undergoing treatment. But if they run out of that time, then the employer needs to look and see whether it is a reasonable accommodation to give them an additional period of time to recover, to seek the treatment that they need. Maybe it can be done on an intermittent basis. Maybe they could work telework for some of the time. But the ADA and the FMLA could both, first FMLA would run and then ADA would run. Okay, next slide. So next, what if an employee is exposed to COVID-19 and must quarantine, but then gets sick and is hospitalized? So that first, the exposure to COVID-19 would result in a quarantine or isolation order, and that would trigger the right to take paid sick leave under the FFCRA. And that means that they could take up to the 80 hours for that purpose. But what happens if they then get sick and they're hospitalized and the hospitalization goes on for a while? That would potentially be a serious health condition under the FMLA. And if it was really serious, or if they didn't have much FMLA time left because they've used it for parental leave or some other purpose, then possibly we get into the ADA. We have a situation where all three of those laws could eventually come into play one after the other. Again, it's going to be important to look at what is the reason that this person is taking this leave. Do they have any time left? Are we running any of these leaves concurrently? Does one follow when the other one expires? So in that case, it could be all three. The next, when an employee is diagnosed with COVID-19 and recovers, but has a weakened immune system and is advised by the doctor to work from home. So again, if the employee is diagnosed with COVID-19, or even if they're not diagnosed and they just were exposed, there is the ability to take up to the 80 hours of paid sick leave under the FFCRA, again, through December 31st and maybe beyond if it's extended. But then they come to you and they say, I have a weakened immune system and I've been advised by a doctor to work from home. That is not FMLA leave because they want to work from home. So they could be working from you, they're not taking leave, but this could trigger the ADA, or this would trigger the ADA. If they come to you and they say, I have a disability, is impacting the ability to be at work, which might be an essential function to be in the building, but I can still do my work if you give me this accommodation that allows me to work from home. So the ADA interactive dialogue would start at that point, and you would want to get medical documentation and have that discussion with the employee about whether that is the most effective or the effective accommodation that you're prepared to give. Okay, next. So the next example, what if a first responder is exposed to COVID-19 and is advised to quarantine and then becomes sick? So being exposed to COVID-19 would result in an order to quarantine or isolate, would be enough to take FFCRA leave up to the 80 hours of paid sick time. But then remember the executive order that the governor signed in April, which says that first responders in New Hampshire who, if that first responder then becomes sick, has a positive COVID test that's reported to DHHS, that is then a presumption that that employee was exposed at work, is infected at work, and is entitled to benefits. So at that point, workers' comp would kick in under that executive order. And just to throw more into that, if it's a serious health condition that goes on, remember that the employer can be running FMLA simultaneously with that. Okay, the next one is when an employee is at high risk due to a pre-existing medical condition and is advised by a healthcare provider to self-quarantine. So if this individual doesn't necessarily have any symptoms, has not been diagnosed, but has been advised by a healthcare provider to self-quarantine for a period of time, that is an FFCRA reason that could justify taking the paid sick leave component of the up to 80 hours of paid sick time. And with more documentation, if the employee wants to be out for longer than those 2 weeks of time, with more documentation, it possibly could be Family Medical Leave Act leave because they have a serious health condition. Maybe they will not work at all and be taking FMLA. Maybe they'll take FMLA intermittently. Or it could be an ADA accommodation. Maybe they're allowed to telework from home after the 80 hours of leave expires. So I know I'm moving quickly. I wish I could see your hands, but those are some areas where the laws could apply at the same time. Next slide. What about some areas where you might get tripped up into thinking numerous laws would apply, but they might not? So let's look at a situation where an office employee tests positive for COVID-19, but there's no evidence of any exposure at work, no other positive cases, all COVID protocols are followed at work, and there's not strong evidence that the employee has followed COVID protocols outside of work. You know, they may have been at a wedding and you know that there was no mask wearing at that time. So for example, you know, an employee that just is not following those guidelines and they get sick, what might apply? Under this situation, FFCRA, the paid sick leave, would apply, right? They have at least through December 31st and perhaps beyond if the office employee tests positive. It potentially could be FMLA if they get seriously ill afterwards. But it's probably not workers' compensation. Even though they're in your office, it probably won't be unless there is some sort of ability to connect it to the workplace. Again, that's a decision that the carrier will work hard to figure out, but on its face, it might not be a workers' comp. Next slide. So what happens if an employee is a close contact of a COVID positive person, quarantines for 14 days, but then needs the time off to care, or needs more time off to care for a family member who was a close contact at their school, where the school is still open? So that employee, being a close contact of a COVID positive person, would likely be asked to quarantine, which would then entitle them to up to the 2 weeks, the 10 days, 80 hours of paid sick leave under the FFCRA. It wouldn't then, the extra time that they need to take care of a family member who was a close contact would not be covered by EFML, the Expanded Family Medical Leave Act, because the reason that the employee is needed to care for the family member is not because the school is closed, but because the family member can't go to school because of their own health condition. But if the employee has already used up their 80 hours for themselves, they don't get additional time to take care of that family member. And even though the reason that the family member needs to be cared for is because they're not in school, it's not because the school is closed. So it would not be that extra up to 12 weeks or up to 10 weeks in this case, because the first 2 weeks are gone. You wouldn't be able to offer them the EFML. It's probably also not FMLA leave unless that family member, that student, develops a serious health condition, gets sick with COVID and develops the serious health condition. Or maybe they have a serious health condition, but that's completely separate and you'll deal with that as a strictly FMLA question. And it wouldn't be ADA. Again, under this scenario, the family member is apparently fine. They're just a close contact of someone at their school. They don't necessarily have a disability. And by the way, the employee doesn't have a disability. And that's what the ADA is focused on, is the employee, the one who's disabled. So a lot going on there. Next one, which is just a slight twist on the prior example. If an employee is a close contact of a COVID positive person and quarantines for 7 days, but then needs time off to care for a family member whose school is closed. So breaking down what they would be able to take, they would get up to 2 weeks or 10 days of FFCRA, because both of these are FFCRA reasons. Number one, the employee is a close contact and has to quarantine, so they get FFCRA leave for that. Number two, they get FFCRA leave because reason number 5 is if you need time to take care of a child whose school is closed. But they only get the 10 days or the 80 hours of FFCRA if they're a full-time employee. So 7 days of that is the employee's own quarantine. 3 days would be for childcare. So that uses up their paid sick leave component. But then because the employee is needed to care for the child whose school is closed, they would get up to 10 weeks of FFCRA to care for the child. If the employee takes the full EFML, there's no FMLA left if the family member later gets sick. So if they take those full weeks of EFML, because the school is closed, and then at the end of that child gets sick with a serious health condition, there's no FMLA left. Because remember, the EFML and FMLA are using that same bucket of 12 weeks of time. FMLA time, there's not new time. It's dealt with at the same 12 weeks. You want to make sure you're counting EFML against your FMLA allotment. And there would not be any ADA here because there's being close contact of a COVID positive person does not rise to the level of a disability. Okay, so just a few words on the impact of COVID-19 going forward. Obviously, we've talked a lot this morning about leaves of absence and about what information employers need to have or can ask for and documentation they can get. In this era, there is a lot more medical information flowing from the employee to the employer. And there may be some unknown disabilities, or previously unknown disabilities, that now the employer is aware of. The employer may not have known about a severe anxiety disorder. The employer may not have known about a history that led to the employee being immunocompromised. So there is more information that the employer now has available because of the requests for leave that are coming under the ADA, the FFCRA, the FMLA. So the employer's knowledge of medical conditions is now increased. And that could lead to employees being suspicious of a connection between the employer's knowledge of their disability, their mental health issues, or their physical conditions, and any adverse job action. So watch for retaliation. Watch for situations where an employee says, did I not get that promotion because I just told them about my severe anxiety? Did I just get furloughed because they know that I have a history of cancer and that I am immunocompromised? So be aware that you have now much more information as a result of all of these laws, which allow you to get some of this information for the protection of the workplace. But now you know it, you can't unring that bell. Be very, very cautious to make sure that you are documenting what you know, how you know it, and when you make a decision about employees, that you're documenting specifically what you relied on, so that you can show you had a legitimate business reason and it wasn't based on some of this medical information that you now have. Another area that you want to be very careful about going forward is the idea of remote work as an accommodation. Obviously, many employers who objected strongly to any work from home before this have now seen that it maybe can work. You may have situations where employees had been asking for that for a long time. The employer said no, and now it has been shown to work successfully in some cases or most cases. So the question about remote work as an accommodation could really pick up a lot of steam after this is over. It will possibly change the landscape entirely going forward for a lot of workplaces. But it is important to recognize from an employer's perspective that the EEOC has said that granting telework during the pandemic does not require the employer to grant remote work as a reasonable accommodation to every employee with a disability after this is all over. So that's an important thing to keep in mind. You will want to make sure that you're having an interactive dialogue to explain that that was a specific period in time that people had to be working out of the office for everybody's protection, but now you need the teamwork and collaboration and in-person presence. So, but it is something that will become an issue, we're sure, after this is all over. So finally, just want to point out, next slide, that you shouldn't forget other laws. We focused on these 4 laws this morning, but don't forget there are other laws in play. And particularly if you are in states, multi-states, you want to make sure you are paying attention to state leave laws, especially if employees are working remotely for a long period of time. You're going to want to know what leave laws, paid sick leave, family medical leave, as I mentioned, the mass paid family medical leave taking effect on January 1st is going to change the landscape for a lot of employers who now will have to add that law or Maine's law or Connecticut's law in when they're looking at this whole alphabet soup, making sure that you're going through your checklist and figuring out which law applies, what does that law require, does this employee have the right to take leave under that particular law. And then there's always other laws that could impact this with regard to leaves and payment for leaves. Don't forget about USERRA, the military leave requirements. Don't forget about the Fair Labor Standards Act and other wage laws that may require payment, especially to salaried employees who work for a part of a pay week, for example, in New Hampshire. And don't forget your own policies. You may have varied, given some variations to some of these FMLA and other laws. And you want to make sure that you're following what your written policies are or your practices have been. And of course, and more. There may be other things that we're not thinking about, but make sure you're looking holistically at a situation rather than just saying, okay, this one law applies and I'm going to follow that to the end and not pay attention to the whole picture. So that is all that I have. I see we have very few minutes for questions. But let me see some of these. I'll take an easy one. Is there a timetable as when the secretary will define other reasons for paid leave under the FFCRA? Well, I think the clock is ticking on that. The FFCRA, as I mentioned, expires on 12/31. We have good reason to think it will be extended, but we don't know for sure. And at this point, the secretary has not defined other reasons. So right now, for under the FFCRA, we're looking mainly at the 5 active reasons that I talked about. Okay, and someone has asked, can you clarify if the EPSL, so the emergency paid sick leave, falls under FMLA, or is that only the EFMLA? Should employers be sending out an FMLA designation notice when providing the EPSL or the EFMLA? So remember, we have 2 categories of FFCRA leave. We have the paid sick leave component with the 80 hours, and that's in and of itself. It's the 80 hours, up to 80 hours, and it does not have really anything to do with your FMLA process or FMLA leave. It is a separate bucket of 80 hours of time. So when that happens, there's certainly nothing, it's probably a very good idea to document for the employee that you are treating this leave as paid sick leave. And we have developed a form over the past 8 months that we recommend that employers they use, that basically says to the employee, check which box you're taking leave for, and here's the information that we're allowed to ask, give us that information. So if you have a form like that, that is the notice that you're giving out to employees. I mean, you're giving them a notice, but that is the record of their taking the leave. As for the expanded family medical leave component of FFCRA, that is an FMLA program. It's an expansion of FMLA. And I don't know that we've been sending out designation notices, but again, I've been using the form that we had put together so that it is very clear that people are taking that reason number 5. I am staying out of work. I need to stay out of work because I am required to be home to take care of a child. There's nobody else suitable to take care of the child. Also answering the question, if the child is over age 14, are there special circumstances that require me to be home during the day to be with this child? So we get that information on that form, and that is the record. I'm not aware that employers have been sending out the FMLA designation notices on that. Somebody asked to clarify a fitness for duty release prior to return from leave acceptable related to FMLA, but not the ADA. And FMLA definitely allows a fitness for duty. It's in the regulations. So yes, you can ask for a fitness for duty. You should put that in your original, the designation notice, so that you can ask for it at the end. But under the ADA, I would say it is also appropriate to ask. That's a program, that's an unpaid leave that you're offering. So you can put those conditions on it. So I noticed that it's 9:30. And I want to be respectful of everybody's time. I do have the questions though, and I will look at those, and if there's some sort of general advice that I can give, I'll certainly reach out to folks. But at this point, I do want to be respectful of everyone's time and point you to the slide which talks about the credits for SHRM. So thank you very much for joining me this morning, and everybody stay well and stay safe. Thank you very much.